But looking through some of the what the judgment that was handed down said was, Justice Kolawole Motosho said that, well, look, the Federal High Court, of course, which was sitting part, declared null and void the direct and indirect primaries conducted by factions of APC because there was a pendency of the matter before the judge, and so you couldn't have gone ahead and conducted those primaries while this case was pending. But you were saying it wasn't pending, contrary to what the ruling has said.
No. Now let's understand which case was pending. Which case was pending, because the Federal High Court cases that was decided by Justice Omotosho came long after the primaries of APC. So which matter are they talking about that was pending? If the judgment is referring actually to the case of Justice Chinwendu Wogu, then it boils down to the earlier point that I've made, that the right of action in that matter does not inure to PDP until after election. Now, the question we should ask is, what is the law upon which PDP went to court to challenge the validity of the Congress of APC? What is the law? Election-related matters are sui generis. They must arise from legal rights that are established from the Electoral Act and the Constitution. So what is the right that is conferred on PDP?
Let me ask you then.
Judgment of Justice. Yeah, go ahead.
Because part of what the question that was put out was that, look, the judgment of Justice Wogu that nullified the primaries of APC in the state is yet to be set aside and remains valid. That's what they said. Isn't that the case?
Okay.
Has that been set aside?
Let us even take it from that point. Let us even take it from that point to show that the PDP case is premature. Let us even take it from the point. The judgment of Justice Chinwendu, the time for APC to attempt to set that judgment aside has not elapsed at all. There is a pending appeal against that judgment before the Supreme Court. The APC has challenged that judgment, having lost at the Court of Appeal, and they have challenged that judgment up to the Supreme Court now. But let me read something that is very intriguing that people should hear. The question we should ask is, what was the issue even before Justice Chinwendu? If I could read what the reliefs were before Justice Chinwendu, Relief 1 states a declaration that the applicant are entitled to participate in world congresses having paid the requisite nomination fees. Relief 2 says a declaration that the exclusion of the applicant from the participating in world congress is unconstitutional and void. A declaration that the purported World Congress is held by APC on May 5, 2018 is null, void, and of no effect. Perpetual injunction restraining APC from conducting LGA congresses or further congresses in Rivers State based on the World Congress election purportedly conducted on the 5th. Mm-hmm. And then the last one is a perpetual injunction restraining APC from recognizing or accepting any result of world election arising from the purported World Congress in 2018. Now, the real question that we should ask is, how does this constitute a pre-election matter, or how does this involve the primaries of the APC? The answer is obviously none. Okay. Again, yeah, but we need to ask, where this
all of what you have cited, notwithstanding,
pre-election,
all of what you've cited, yes, notwithstanding,
yes,
isn't still truth and the fact that that same judgment has not been set aside, which you say that in the process, so that's valid.
Now the fact that's the point we're making. That's the point we're making. We're saying that PDP is jumping the gun. The fact that the judgment has not been set aside has not foreclosed the right of APC to set aside that judgment has not been foreclosed. There's still a window for the Supreme Court to look at the matter, and that window is still open. So if the court, let us even take the extreme scenarios that they're saying, assuming that INEC acts irrationally and decides to remove APC's name from the delete APC's candidate from the election, and then at the end of the day, the Supreme Court upturns that judgment of Justice Chiwendo, what sense does it make? It makes no sense. And that is why the right of a third party to challenge the nomination of another political party only endures after the election in question. And the provision to do that is before an electoral tribunal. They are not foreclosed at all. It's for them to appear before an election tribunal to say that the person, candidate of APC who has won the election, is not a person validly nominated in law. They cannot go to court to preempt APC from running an election. That is not acceptable, part of what they said in supported by law. Part
of what the judgment said in Senator Abe's case, for Abe and 48 others, was that number one, that both the direct and indirect primaries that were conducted by both groups, null and void, illegal, because there was a pendency of a matter. And so the court had, while the matter was going on, both parties were supposed to stay action. But if they went on, the court simply said that is unacceptable. And as a result of that,
no, Chamberlain, let me correct. Let me make a point now. Let me make a point.
Go ahead.
Let me make a point. Let me make a point straight away. The point, first and foremost, we need to understand. We need to understand that APC as a political party has the right to schedule a Congress, reschedule it, or even outrightly cancel the Congress. Now, at the beginning of the Congress on the 5th of May, 2018, some aggrieved members of the party felt that they were excluded from the process. They wrote to the national body of the party. While that body was yet to come up with a finding, they approached the court. First and foremost, they did not exhaust the internal mechanisms of the party, but that's on the merit of the case. Now, the party looked at the whole situation and came up with a finding and said, look, there's no need excluding anybody. And the party decided to terminate the congresses of the 5th, 12th, and 19th, the World Congress of the 5th, the World Congress, the LGA Congress on the 12th, and the State Congress on the 19th. The party effectively terminated it via a letter of 18th May 2018, and set up clearly distinct congresses. World Congress of 19th, LGA Congress on 20th, and State Congress on 21. Now, what the parties are doing, which is very worrisome, is that the parties do not, the persons involved do not want the court to even hear the merit, because they know that once the court hears that matter, the court will be able to say clearly that the letter of the party, National Working Committee of the party of 18th May 2018, conclusively and effectively terminated the congresses that they are relying upon.
Yeah, but
that is why they don't want the matter to go on.